Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Before arguments commence, a brief attorney admission ceremony will be conducted. Chief Judge.
Thank you. On behalf of myself and Judges Wilkins and Walker, I'd like to welcome you to this attorney admissions ceremony. As you probably did not learn in your bar review course, this court was formed by an act of Congress on February 9th, 1893, and was originally called the Court of Appeals of the District of Columbia. The court was then composed of one Chief Justice, as the position was then called, and two Associate Justices. It was not until 1948 that the court was given its present name, and that we renamed and seemingly demoted from justices to judges. Since its founding, the court has grown from 3 authorized judgeships and now has 11. 68 judges have served on the court, including the 11 active and 4 senior judges who now sit. Part of what makes this court very special are the members of the bar. The bar of the DC Circuit is made up of many highly regarded and skilled advocates. Our bar members also have a history of providing able pro bono assistance to the less fortunate. The bar's pro bono service enables the court to do its own work better because we know that the parties are receiving effective legal representation. We hope that you will all consider participating in the court's pro bono program in the future. We know that you've all worked very hard to get where you are today, and you all should take great pride in your accomplishments. As you move forward in your careers, we know that you'll have occasion to think back and thank those who helped you get here. And in the future, we hope you'll help pay that help forward by helping someone else who is just starting out in his or her career. We're particularly pleased to see so many of our judges' law clerks being sworn in today. It's been a pleasure working with you over the past year, and I'll leave up to you to determine whether you think it's been a pleasure to work with us. And I know I speak for all of us in saying that we eagerly await your return to the court as counsel.
Will the following individuals please stand as you are called and raise your right hand for the administration of the oath? John S. Acton, Zachary A. Austin, Christopher J. Baldacci, Saxon Cropper Sykes, Gabrielle D. Doman, Anuka Dunbar Gronke, Ian W. Fraser, Claire E. Groden, Victoria Columbi, Mahir Katarpo, Anna Marie Elizabeth Costil, Alexander J. Krasuski, Kafir J. Lang, Jeremy P. Lewin, Eileen Lee, Tyler Blake Lindley, Cynthia Y. Long, Nicholas A. Mexis Paxson, Nikki Memarzadeh, Cody R. Milner, Matthew E. Morris, Alexander Nabavi Nori, Nora Elena Rast, Hallie Saunders, Reno G. Varghese.
Thank you. If you'll all please repeat after me. I state your name. Do solemnly swear or affirm that I will conduct myself as an attorney and counselor of this court uprightly and according to law, and that I will support the Constitution of the United States. Congratulations to all of you, and welcome to the bar of the U.S. Court of Appeals for the D.C. Circuit. We look forward to your first appearances before the court, and we know that you will serve well the cause of justice in this circuit.
This concludes the attorney admission ceremony. Case number 23-5169. Dorian Van Horn, appellant, versus Carlos Del Toro in his official capacity as Secretary, U.S. Department of the Navy. Mr. Erickson for the appellant, Ms. Kurdeman for the appellate.
Good morning, counsel.
Good morning, Your Honors. May it please the court, Neil Henriksen on behalf of Dorian Van Horn. Your Honors, this is an age discrimination case for a seasoned federal law enforcement employee that revolves around forced transfers at the Naval Criminal Investigative Service. The district court, in its ruling, in particular at Joint Appendix 961, 962, but throughout, established a standard that this court had in 2022 in the en banc decision of Chambers versus District of Columbia, really had done away with in terms of having an objective, tangible employment action at issue. And the Supreme Court just 3 weeks ago, and we did not update the court on this, but have become aware, Muldrow versus City of St. Louis, 1445, Supreme Court 967, April 17th, 2024. In essence, really inconsistent with this court's ruling in Chambers versus District of Columbia, says that, especially under Title VII's terms, conditions, privileges of employment language, and eradicating discrimination, that there doesn't have to be this tangible effect where there's a transfer at issue. And in this case, it is all about transfer.
Did the district court's opinion even cite our en banc decision in Chambers?
Does not. And in fact, Your Honor, the district court cited district court opinions and other opinions that predate Chambers and relies on Brown versus Brody, which was overturned by
So it
Chambers.
did not cite the en banc decision from within the past 2 years that directly controls, that it instead repeatedly cited pre-Chambers precedents that were overruled by Chambers.
That's correct, Your Honor.
So I wonder whether we shouldn't just vacate the decision, which I think you would like, then remand for the district court to apply Chambers.
Well, I think that's something that the court could do, but certainly, and the court has had this record for many years. It dealt with motion for judgment and in the alternative summary judgment years ago in this matter, denying in part. But the court really did not focus really, and again, we think the court could reverse and remand and set it for trial, have the district court set for trial.
Do you know how long the summary judgment motion was fully briefed before the decision was made?
Well, I think it was approximately not quite a year, but I know, for instance, in the opposition by plaintiff, we do cite Chambers versus District.
Oh, no, I know that.
Yeah.
I'm just wondering.
Yeah.
How speedy it went along or how not speedy.
Yeah, this case was because of the pandemic also was slowed down in the briefing schedules from the very start in the case. And that's really in many ways dispositive because there's, we think, viewing the facts in a light most favorable to Ms. Van Horn, taking all inferences in her favor, there were abundance of facts that there were negative consequences related to these forced transfers that were in violation of NCIS's own procedures and regulations in terms of how do you select out a officer for transfer. And in particular, we go through that in the brief, but that very first transfer out of the United States, and this is an officer with over 24 years of experience, was stationed at the headquarters. Their procedures and policies have a mobility exemption for someone in that position. They have to be there at least 2 years. That was not abided by. That there's a bidding process, that Naples, Italy posting had over 5 bidders. The original bidder selected by the panel, Mr. Biggs, eventually was selected by upper management.
I want to ask you about the mobility policy. So the defendants say that the mobility policy should be read, and I'm looking at the language as it appears on JA 67. I think it's appears several places in the appendix. That if she had been at headquarters for more than 2 years, kind of in a previous assignment, then the mobility policy exemption does not apply. What's your response
Well,
to that?
Our response is that the her position was a GS-13 originally. That position's abolished, and the Special Agent Van Horn has moved into a supervisory position in February of 2011, is there for 10 months, and at JA 454, and Your Honor's right, of course, there's various copies of this policy, some of which are extraordinarily hard to read in this. And so JA 454 has the mobility policy at 13.2, 1C, which is the exemptions for the mobility policy. So Van Horn had moved into a supervisory role and did serve for less than 2 years in that position. In addition, 13.
Is there evidence in the record that this was her first supervisory assignment?
She had other types of supervisory assignments, but this was a distinct one. It moved from a GS-13 level to a GS-14, and a GS-14 and 15 were seen as executive service, so to speak. That's not what they called them within NCIS. And so, it's not only that exemption over the 2 years, it's the way the bidding takes place and the way the bidding is required for these positions under Chapter 13.16C2 at JA 464. And in that setting, it is only after a they get no bidders for a particular posting, and they then can move to forced transfer. Now, that's not mandatory, because if there are exceptional, extraordinary circumstances that might require someone, my client knows that because she is transferred many times in the course of her a little over 24 years with NCIS, and knew that was a requirement of the job. But there's certain ground rules that all employees expected, and that management had an obligation to incur. And also, importantly, we're dealing with 633A of the ADEA, which has, as Babs versus Wilkie makes clear, that any personnel decisions be made free from any discrimination. And that language, as Justice Alito in Babs versus Wilkie, and the opinion in that case by the Supreme Court, recognized that is extraordinary protections. Now, in this case, the district court did not treat the decision-making as needing to be free from any kind of taint of age. And it clearly was in this instance, looking at the facts, again, in a light most favorable to Ms. Van Horn.
Can I ask you another question? Your complaint requests front pay. Am I correct about that?
It requested at a time when, years ago, when this was originally had been filed. At this point, there would be a different type of relief. So we're not at this point seeking, we're seeking, the years have gone by, so it's primarily back pay. There is a special type of position that a retired NCIS experienced agent could take on at NCIS that really goes outside this record, but where there are opportunities for pay that could come up.
I'm not understanding what you mean when you say circumstances have changed or something and you're not requesting front pay anymore.
We are in this case, we're requesting front pay in that Van Horn shouldn't have retired when she did. The years have gone by where she had to retire at age 57. More than 7 years has gone by since the pendency of this matter.
Okay, I understand that. I'm just trying to nail this down. Because in a situation like this where someone is terminated or they're forced into retirement and they allege that that was wrongful, even if they can't be reinstated, the typical equitable relief is front pay, where the court tries to envision what they would have earned if they hadn't have been wrongfully terminated or
Of course.
wrongfully forced to retire. And I'm just trying to understand, is that something that you are seeking in this case?
We have always been seeking it. We seek it now in a little less traditional version of what you're saying because of the age 57 mandatory retirement. She was 50 years old approximately when these adverse actions
So
happened.
obviously you can't
Yes.
get front pay past age 57.
Yes, maybe, because there's a certain type of position that can be taken by the officer. Thank you. I see my time's up.
Alexander, okay, we'll give you a little bit of time for rebuttal.
I had 2 minutes, Your Honor.
Well, yeah, we'll give you some time.
Thank you.
Ms. Kurdeman?
Good morning. May it please the court, Deidre Seibel-Kurdeman for Secretary of the Navy. The Naval Criminal Investigative Service has a global mission, and to this end, it employs approximately 1,100 special agents across the globe in approximately 130 offices globally, consistent with its mobility policy and mobility agreements that special agents sign upon entry with NCIS. This is exactly what happened when the NCIS selected Ms. Van Horn to serve in a Naples, Italy position in 2012. Following her refusal to report to Naples, Italy, and her intent to retire come September 2012 when she had not retired, the agency had no other place to put her but the only GS-14 validated billet available, which was in Great Lakes. There was no constructive discharge. Should the court agree, Ms. Van Horn is left with no other remedy under the
Can I ask,
ADA.
You don't take issue with the notion that the district court's adverse action rationale doesn't stand up in the wake of Chambers and Muldrow?
That's correct, Your Honor. We are not disputing that Ms. Van Horn has viable claims here. That said, we take no position as to the court's underlying decision.
What
In terms of like suggesting that there was error or anything to that point. But we do not dispute that she has viable causes of action and that under the ADEA, there were personnel actions that occurred.
So if we thought that, if we were to agree with you on that, are there grounds that you're asserting on appeal for affirmance that are grounds that the district court reached?
That the district court reached, Your Honor?
Yeah.
We briefed everything that we presented to you
But
today.
that the district court reached?
No, Your Honor.
Okay.
Not to my knowledge. And I believe the suggestion that Judge Walker had asked with my friend on the other side as to the time that the facts were actually briefed and the court rendered a decision was approximately October 2022, fully briefed, and then the court rendered a decision in June 2023. All that said, though, the government submits to you that we have put in the briefs legitimate non-discriminatory reasons, and there's no suggestion of pretext, such that this court could rule de novo in the sake of judicial economy in favor of the government on the reasons we submitted.
I'd like to ask you about that. The mobility policy, I don't know if you can get it in front of you. I'm looking at J67.
I'm sorry, which number are you at?
JA67, the exemptions from the mobility policy.
Mhm.
And just looking at the first one at 1A, the first time supervisor in their first year of a CONUS assignment, and CONUS means within the continental United States, right?
That's correct, Your Honor.
So let's suppose you have someone who joins NCIS, their first assignment is in Boston, and they serve there for 5 years in a couple of different assignments. And then they become a supervisor for the first time, and that's their third assignment. And that assignment is also in Boston, so they don't move. But 6 months in that assignment, they're told you have to transfer to Naples. And they say, I don't want to transfer, and I should have an exemption under 1A. Do they have the exemption?
if I might just ask, I'm sorry, how long under your hypothetical was the person in the supervisory role?
6 months.
Okay, thank you, Your Honor. I will admit to you that this policy does not suggest that there's a time limit by which the person was serving as a supervisor before they could be relocated. I think it would likely be that this person would have an exemption. It would be incumbent on that person, however, to submit a request for reconsideration of that selected transfer and note the exemption. I will say, Your Honor.
The reason that it would appear that they have the exemption is because it's written to be basically focused on not just the location, it's not location specific, but it's assignment specific.
That's correct, Your Honor.
And isn't C also assignment specific, serving in a headquarters assignment for less than 2 years? I mean, what difference does it make if they've had 5 headquarters assignments previously? This is a new assignment. And if they're less than 2 years into this assignment, then they get the exemption. Why isn't that a reasonable reading of this policy?
Your Honor, I think it's an unreasonable reading because headquarters is modifying assignment, suggesting that anyone that is serving in a headquarters assignment for less than 2 years collectively, not somebody who was recently promoted.
But assignments, it doesn't say assignments, it says in a headquarters assignment. And it's different than D, which says employees assigned to the CRFO, and that's the Contingency Response Field Office in Glencoe, Georgia, right?
I believe so. I believe that's correct, Your Honor.
So they could have said if you were assigned to headquarters, you get an exemption, or could have made it completely location specific, but it's not. I mean, isn't this a jury question
I don't think.
of whether or not this is pretext, whether or not there was a violation of policy? I mean, that's what we have juries for. When the defendant says, oh, we were following policy, that's why we terminated this person, or that's why we took the employment action. And then if the plaintiff raises an issue of like, well, the policy is ambiguous, or I didn't really violate the policy, or you're not consistent with how you enforce the policy, we let juries decide those.
So, Your Honor, I would respectfully submit it is not a question for the fact finder. On these facts, there is no inconsistency in the record in terms of how NCIS applied this particular policy. My second response would be that headquarters is modifying assignment, which is basically akin to D, where it states that employees are assigned to the CRFO. There's not much like.
But CONUS modifies assignment in A, and OCONUS, which means outside the continental United States, modifies assignment in B, right?
That's
so
correct.
If you had a situation in B where, let's suppose somebody joins NCIS and they're in Naples for their first assignment, and they're in Naples for their second assignment, and then they become a supervisor for the first time in their third assignment, and 6 months into their first time supervisory assignment, also in Naples, they're told, okay, we want to transfer you to Iraq. And they say, I don't want to go. Under B, does that person have an exemption?
Well, there's a couple of differences between B and C, as well as A and C, and that is A and B are
But
talking
answer
about.
my question, under B, in that hypo, does the person have the exemption?
As long as they are first-time supervisor within the first 2 years of their outside the United States assignment.
So in this hypo that I gave you, what is the answer? Yes or no?
If you don't mind repeating the hypo, Your Honor, because I'm forgetting in terms of the application of the
So they've
years.
had 2 prior assignments in Naples lasting 5 years. And then in their third assignment, which is their first supervisory assignment, also in Naples, 6 months into that supervisory assignment, they're told you have to transfer to Iraq.
I think the exemption would likely apply, yes, Your Honor. I will note that the exemptions from the mobility policy are permissive, meaning that, it says personnel should not expect, but it gives the option to the service to strike the proper balance of mission needs, fairness, personal goals, absent extraordinary circumstances. I would submit that the facts at issue here, though, are very different. Ms. Van Horn had been in a headquarters assignment in headquarters since 2002. She had been in a supervisory special agent position since 2005, over 7 years.
But the evidence is undisputed that she was in her current assignment at headquarters for less than 2 years when she was faced with a forced transfer, right?
Respectfully, Your Honor, I know that is not what the facts suggest. She had been in a headquarters assignment because she was assigned to headquarters in 2002 when she moved from LA to Washington,
But
DC.
it's not the same assignment, right?
She was serving within the threat management unit, the assignment, for over 10 years. So, Your Honor, I would suggest that what appellant is suggesting here is that
You saying that at the time, I thought I saw in the appendix an assignment. Because the assignments change every few years. So you're telling me that there wasn't a new assignment. I can't remember the dates from the briefing. Less than 2 years before the transfer at issue.
she had received a GS-14 in 2011, but her position as a supervisory special agent had not changed. That was the position that she had since 2005. And she was assigned to the threat management unit since 2002. So what we are submitting to you, and respectfully, Your Honor, that she had been assigned or had been in a headquarters assignment since 2002.
I have one
Go ahead.
I have one question about the transfers. I was going to switch subjects. The part of the district court's rationale as to two of the possible transfers to Naples and to Great Lakes, I think, was that those don't matter because they never came to fruition.
Correct, Your Honor.
And I take it that you're not defending that part of the district court's rationale.
That's correct, Your Honor. We would submit, though, that there were legitimate non-discriminatory reasons and no pretext for those transfers, one of which was temporary, but we are not disputing that. Those would be actionable under the ADEA.
Even though they didn't come to fruition.
That's correct, Your Honor.
Okay.
Can you pull up JA 747, please?
Yes, Your Honor.
So this is a deposition of Eileen Hogan, who I believe is a naval official.
Correct.
And at the bottom, I'm looking at line 17. The question began at line 8. And the question was, when the decisions were made in early January 2012 were made for the early January 2012 involuntary transfer of Ms. Van Horn to Naples, Italy, NCIS was aware Ms. Van Horn had had less than a year of supervisory experience. Is that right? There's objections. And then the answer is she had been in that assignment for less than a year.
That is what the deposition states as it relates to the position she had been in January 2012. If I could submit to you, though, that the SF-50s that are at JA 560 show her assignment to headquarters in 2002 on 559. On 560, she was assigned to, she was in the same position, the Naval Criminal Investigative Service and the Crimes Against Person 23B. And on 560, she was assigned from a criminal investigator to a supervisory criminal investigator. And then on 561 in 2011, she received a she had received a GS-13-9, which she was moved to a 14-5, if you see in 18 and 19. So that question is referring to the fact that she had received a GS-14 on 2/27/2011.
Okay, I'll take your answer, but the question that was posed to the witness was, when did the assignment begin? And the witness said that she'd been in the assignment for less than a year. You do agree with that, right?
I do agree that Mr. Hogan in that particular question had stated that she had been in that assignment for less than a year, but that was in conjunction with the question being asked, what position she was in as of January 2012.
All right, thank you.
Thank you.
I have one quick question.
Yes.
The validity of each subsequent action and transfer depend heavily on whether the initial transfer to Naples was proper.
That's correct, Your Honor. And one more thing, if I might just correct the record, my friend on the other side had said that there was a reason, that the position had to be re-advertised prior to making a selected transfer. That provision was amended in 2011 and was no longer in effect at the time that she was selected for the transfer. That can be found at JA 475.
Thank you, counsel.
Thank you, Your Honors.
Mr. Henriksen, we'll give you the 2 minutes that you'd asked for.
Thank you, Your Honor. With regard to the Judge Wilkins' question to counsel at 561, Joint Appendix 561, the effective date of the position Van Horn was in beginning in February of 2011 until the forced transfer date, approximately January 5th, 2012, is set forth in that personnel action. And it's also found more of an explanation of it, and Your Honor had cited the testimony of Mr. Hogan, but there's also at JA 641, paragraph 6 of the declaration of Ms. Van Horn, effective in 2011, I was promoted by NCIS from a GS-13 supervisory agent into a new billet as a GS-14 divisions chief stationed in headquarters of NCIS. There's that testimony. There's the personnel action at JA 561, and there's the testimony, Your Honor, raised with regard to that.
Well, the government says that at 561, it says promotion as far as nature of action, and that at the top there, that box number 5B, I think it is. Whereas if you look at 560, the personnel action in box 5B says reassignment. That was in 2005. So I think that your friend on the other side's argument is that this was not a new assignment. It was a promotion, but not a new assignment within the meaning of the mobility policy.
Right, and Your Honor had referenced that JA, I think 67, I had 454, that policy exception C, employees serving in a headquarters assignment for less than 2 years. And viewing the facts in a light most favorable to Ms. Van Horn, drawing all inferences, is that that was a new assignment. The prior assignment had been abolished. That was no longer a position. That was no longer an assignment, Your Honor.
All right.
Thank you. Thank you,
Thank you,
Your Honor.
counsel. Thank you to both counsel. Take this case under submission.
Case number 22-5251. Michael S. Owlfeather-Gorbey, aka Tsunami Khan, appellant, versus Avery, Captain, USP Thompson, et al. Ms. Geba, amicus curiae for the appellant, Mr. Dreyer for the appellees.
Good morning.
Good morning, Your Honor. Erica Hashimoto from Georgetown University's Appellate Litigation Clinic. With the court's permission, third-year law student Sonia Geba will be presenting the argument on behalf of amicus.
Thank you. Ms. Geba.
Good morning, Your Honors, and may it please the court. This court need not strain its reading of imminent danger in this case. Even the government agrees that Mr. Khan's acquired blindness from worsening glaucoma poses a danger of serious physical injury. Indeed, Mr. Khan's advanced and complicated condition has already caused him to lose over 95% of his vision in one eye and over 65% in the other due to delayed and denied medical care. He faces complete, irretrievable loss of the vision that he has left. And while he faces total blindness, he also alleges an ongoing pattern of brutal physical assaults in retaliation for his complaints. In total, his filings detail at least 6 specific assaults plus 2 more threats of serious harm by 4 individuals over a 4-month period at USP Thompson. Mr. Khan has already met the high standard this court has established for imminent danger claims. He has alleged sufficient specific factual allegations of serious imminent dangers. The PLRA's 1915A screening device also encourages district courts to dismiss frivolous claims before a case is even docketed. Further, the PLRA's legal constraints that already narrow the imminent danger exception, assessing the seriousness, imminence, specificity, and nexus of allegations precisely at the time of complaint and notice of appeal, are more than enough to safeguard this court from meritless suits.
Can I clarify something?
Yes.
I mean, if the lawsuit is not seeking relief from the physical assaults, it's not raising, some sort of Eighth Amendment or other claims relating to the assaults and seeking to get some sort of relief from the assaults, why are they relevant to whether he can bring a lawsuit related to treatment for glaucoma? I mean, isn't the purpose of the imminent danger language to allow somebody who is in imminent danger to file a lawsuit, notwithstanding the fact that they filed 3 prior frivolous lawsuits, but to file a lawsuit to stop this imminent danger or risk of injury that they're facing?
So Mr. Khan has sought damages in this case, and that is sufficient. Under previous cases, that is a sufficient relief that he could seek for both the assaults and the glaucoma.
But I didn't read his complaint as raising any claims relating to the assaults. Did I miss that?
I believe he did. I might need to check the JA and address on rebuttal, but in his complaint and in the IFP application, I believe throughout his complaint, he brings claims of physical assaults against several different inmates with which he was housed, and complaints against staff who refused to take his grievances. So his claims entirely have to do with assault allegations.
Okay.
Mr. Khan has sufficiently pled not just 1 imminent danger, but 2. So as we've mentioned, first, he alleges delayed and denied medical care, medications for his glaucoma, and access to an ophthalmologist, which is causing impending blindness. This is sufficiently serious under the PLRA's imminent danger exception because it is life-altering and disabling. He's already lost 95% of his vision in one eye, and he alleges a snuff-out syndrome, which his doctors have treated him with, or rather addressed in his medical records, that creates a massive risk of complete blindness. This is also sufficiently imminent under this court's precedents in Ibrahim. For example, chronic illnesses were recognized as inherently imminent and ongoing. So this is also imminent, his glaucoma-related
So
harms.
it doesn't appear to be much of a dispute about that for our purposes here. I guess the question I have is, let's suppose, I know that you have an argument that we shouldn't take account of additional evidence that's submitted by the government in response to our request to respond. But you also have an argument that says that even if we did, the imminent danger threshold is still satisfied. And so let's just focus on that part of the argument.
Sure.
As to that, what in your mind should we do with the notion that the government points out about his declining surgery?
Well, we point out in our brief in response to that question that in 2020, as recently as late 2020, he actually underwent surgery, which was unsuccessful. So the doctors that he's been consulting with in the past, before February of 2021, which was the last time that he saw an ophthalmologist, he's been able to consult with an ophthalmologist to take surgery or not. That's kind of within the scope of the patient-doctor relationship, and so the surgery question is, I think, slightly separate than the core of his allegations, which are that he's being delayed his treatments between 5 and 20 days of medication at a time, which another provider told him that he shouldn't be receiving, or he should be receiving his medications consistently, daily. He should not go any period of time without his medications. And this is also a really complicated case. His glaucoma condition is quite advanced and also complicated by this snuff-out syndrome that he mentions in his filings. It's not clear, even with the doctors that he has consulted, that surgery would be the proper remedy either. It may actually introduce a danger of a total blindness as well.
So I appreciate the point that it's a complicated situation medically, and we shouldn't be in the position of trying to step into the shoes of a physician to figure out exactly what the right course of treatment is. But as a more abstract matter, what should we do with situations in which there's something in the record that indicates that an inmate who's complaining about an imminent danger is declining to extricate himself from the dangerous situation, even though something, let's just say, has been offered to him? But he still says he's in imminent danger, but it's apparent from the record that there's a serious question about whether it's his own conduct that's leading him to stay in a dangerous situation, and he has a self-help remedy that he's just been declining.
I think with regard to, surgery we've already talked about, but
let's put that one to aside, but just as a general matter, suppose you had, for example, a transfer in the assault circumstance. Suppose you had a transfer situation, and the inmate just refuses to take a transfer, says he wants to stay in his cell, and he wants the other person to be transferred who's been assaulting him. How would we deal with a situation like that?
I think this court has certain tools to screen out different kinds of claims. So this court could use some of those tools in that scenario. For example, the court could weigh the specific facts in that scenario and consider whether it's conclusory or ridiculous kind of statement. It could also consider that maybe the harm is not specific enough in that situation, because under this court's precedence, also in Mitchell, a harm needs to be specific enough. A plaintiff needs to allege specific facts, things like dates, people who have committed the harms, and other details for the court to conclude that a harm has occurred and that they are seeking relief from that harm. And so, in the case of someone who is not making certain or taking certain actions, I think in that case also, they could still be seeking relief like damages, which could be, like they could still be seeking that. But I think that this court would have to weigh the facts in that situation and consider whether it's a conclusory or speculative kind of harm.
Thank you. Let me make sure my colleagues don't have additional questions for you. We'll give you some time for rebuttal.
Thank you very much.
Thank you, Ms. Kemp. Mr. Dreyer.
Good morning, Your Honor. May it please the court, Douglas Dreyer on behalf of the United States. I want to start with something everyone agrees with, which is that conclusory, fantastic, delusional, irrational allegations of imminent danger do not satisfy Section 1915G's exemption. And I would refer to page 5 of Mr. Gorby's reply brief, or what we just heard at the podium. But where in the statute's text can we derive that principle from? And it's the statute's text that must control. And so 1915G says, unless the prisoner is under imminent danger of serious physical injury. It is the is that is doing the work there. When a prisoner brings irrational or delusional allegations, courts can determine that the prisoner is not under imminent danger, even if he alleges that he is. But that demonstrates that the question for the court is whether the prisoner is in imminent danger, not merely whether he states that he is. Happy to answer any questions the court may have.
So the idea that we don't take account of delusional allegations, would that deal with the witches hypothetical that you have in your briefs?
It would. And I would also want to point out there's
So there's another tool to deal with that then.
there is, but where does that tool come from? That's not plucked out of the ether. It has to come from the statute's text. And I think that is in the statute's text where it says is in imminent danger. And I'd also point to if page 24 of the joint appendix, his IFP motion states that, Mr. Gorby also owns all of the United States, Mongolia, China, Scotland, and Egypt. So this is already a plaintiff who we know is making fanciful allegations.
But if there's fanciful allegations about one thing, but then there's also allegations about imminent danger, should we discount allegations about imminent danger because of other allegations?
It shows that the court should look closely. And so I agree in the vast ordinary run of cases, the court will look at the complaint, look at the IFP motion, or look at the notice of appeal, depending on what stage we're in. We'll accept the prisoner's well-pled allegations as true and go from there. But in cases like this one, where we're dealing with a prisoner who's filed more than 400 cases and whose own application demonstrates fanciful delusional allegations, let's point out the whole point of this complaint, to go back to Judge Wilkins' question, is that he believes that there is a conspiracy between all members of the Senate Judiciary Committee, the head of the Administrative Office of U.S. Courts, and various Northern District of Illinois judges to conspire against him to interpret Section 1915G too narrowly. So it's not just single lines that I can point to. It is the complaint as a whole.
So if the complaint as a whole has some fanciful stuff in it and surrounding it, then let's suppose that it wasn't that case, but he still has all the same things about glaucoma and inmate assaults. Would such a complaint that didn't have the fanciful stuff that you're identifying, would that get past the imminent danger bar?
Well, so first there'd have to be a nexus, but assuming there is a nexus, then I think if that is the well-pled allegations, that may be enough to get IFP status. But if there is evidence in the record that contradicts that, such as the Moisant Declaration or prior judicial opinions saying that it was Mr. Gorby's own decision to refuse surgery that caused him to get into the situation he did with his glaucoma, the court can consider that. And that, even if the court wasn't aware initially, that can be reason to revoke IFP status. Now, one thing I want to point out is this court has a very narrow strike window for what counts as a strike under 1915G. And it does for good reason. It's because 1915G is supposed to have consequences. And it shouldn't be so easily trounced by a prisoner who can just add allegations of imminent danger that are completely contradicted by the facts.
But if there's just one follow-up. If there's a nexus requirement, which our decisions establish, then the IFP allegations are going to be related to the merits.
Well, at minimum, and I'd say it's more than relate to, but yes, Your Honor.
So they're at least bound up with the merits. So those cases will, if they're that fanciful, will go off on the merits anyway, right?
So, I mean, this is where I want to push back at the notion that the government's position is somehow worse for prisoners. What we hear is this desire to, oh, well, this case can be disposed of other ways. Mr. Gorby has filed approximately 400 cases. Let's assume for easy math, and I know it's actually much more to file an appeal here in DC Circuit right now, but let's assume that's $400 per case or appeal. 400 times 400, that's $160,000 that Mr. Gorby could have owed to the courts if he would have been granted IFP status each time. Now, where I grew up in a small city in what shouldn't be called the Rust Belt, that's enough for a person to buy a nice house for their family. So just believing that, oh, the court can dispose of this the other way, it's not better for the prisoner, and it's also not what's called for in the text. The text of 1915G asks, is the prisoner in imminent danger? And I think Judge Richardson's concurrence in the Hall opinion from the Fourth Circuit the other year, while certainly said some things that I would disagree with, I think it does have a good point, which is unless the prisoner is in imminent danger, then 1915G doesn't apply.
He rejected the redressability idea that you put forward, right?
He rejected the entire nexus idea, including Pinson. So
Because he didn't see it in the text of the statute.
correct. And on that point, I mean, Pinson did settle this in this circuit, but what I would say is Congress had a clear intention with the PLRA, which was to ease a constitutional concern by allowing a prisoner who really was under imminent danger of serious physical injury to get into the courthouse. And so that demonstrates a nexus. And I think you have to read the two parts of the statute together with Congress's purpose in mind to see why the nexus requirement does exist. But that was settled in Pinson.
What about his allegations of, the beatings by other inmates and the guards, spreading rumors and all of that? What rebuttal did you present with respect to those factual allegations?
Sure. One, at the time he noticed the appeal, he was not in a cell with either of the prisoners at question, Kowalczyk or Riggs. So there was no fear of imminent danger at the time he noticed the appeal. Two, I'd point out to the Moisant Declaration, which goes through the only assault that's really described with specificity as to what happened. I believe it says he was hit with a closed fist, which sounds quite bad. But when we look at what actually happened, when the doctors analyzed him, they saw no fractures, no damage to the soft tissue. And this is just another example of Mr. Gorby tending to make allegations that once they're looked at, just don't hold water.
So I'm trying to understand how your legal test would work. So let's suppose we have a hypothetical where the inmate files frivolous claim after frivolous claim, hundreds of them. And the prison officials, according to the complaint and declarations by the inmate, say that basically we are going to punish you for continuing to, harass all of us with your frivolous lawsuits. And the lawsuits continue to be frivolous and fanciful and all of that, but the allegations which don't get rebutted by the government are that he gets a beating after every single one that he files. And he puts that in his, request for IFP status. What do we do with that case where where there's kind of like no rebuttal that he's being beaten, but yet the case itself, you could say that there's no nexus between the beatings and the allegations in the complaint, because the allegations in the complaint are, I want medical marijuana for my glaucoma.
Yeah, then we would be in the same situation that led to Pinson, which was a Gorby case as well. And where the court says, look, there is no nexus. And in Pinson, the court said there wasn't even a minimal nexus. It didn't matter what the particular test was for nexus, whatever it was, Mr. Gorby failed to satisfy it. So I think going the nexus route, which this court has done time and time again. I mean, Mr. Gorby filed, I think, approximately 9 appeals in this court in 2022 alone. Repeatedly, the court dealt with Mr. Gorby's allegations by just saying, look, there's no nexus here, and so denying IFP status. Now here, the court invited the United States' position, so we provided a declaration that sets forth.
So let's suppose we have someone who's filed multiple frivolous complaints prior, but their current complaint is, for religious reasons that are sincerely held. I don't eat pork, but the only food that they are serving to me is pork. And I basically have to eat it or I'll starve. And so I'm being compelled to eat pork against my religious beliefs. I'm not in imminent danger in that, like, I'm not being beaten, I'm not going to starve, but my constitutional rights, my First Amendment rights are being violated. There, you would say 1915G doesn't apply, right?
I mean, I think then the question is, assuming there's a nexus there to the claims, then the question is does that qualify as a serious physical injury? If the court were to assume it did on the constitutional question, then I think to the extent the court were to grant it, if it was then discovered that these contradictions are just untrue, then IFP status could be revoked once presented with contradicting evidence. Now, and I also want to point out the benefit to the prisoner in having IFP status revoked in that situation, if the case was going to be dismissed anyway, which is once IFP status is revoked, they're not going to be on the hook for paying the rest of the filing fee. So it is better for the prisoner, if a case is going to be dismissed anyway, to have IFP status revoked first.
Yeah, we identified that even in our Asamani decision, highlighted for the inmate what the possibility would be if he chose to go forward.
Exactly, Your Honor.
For this reason. To follow up on Judge Wilkins' hypothetical, unless you have fault, in the situation in which the allegation has to do, for imminent danger purposes, has to do with ongoing beatings in the cell, and then the merits of the suit also deal with that. Even if this is somebody who is a serial frivolous filer, 400 complaints, let's say, but if those allegations are in the complaint and they're, at least with respect to the beatings, they're not rebutted by a response that's solicited from the government, then under your approach, there would be a nexus and IFP status would be granted?
I think it would need to demonstrate that there was an imminent danger that the beatings would recur. I think in Asamani in particular, there's a reference that, look, if the pattern gets broken, if there's some reason, say he has been transferred away from the cellmates in question, as happened here, then there'd be no reason to believe it would recur, and so it wouldn't be an imminent danger at the moment.
But if the transfer happens after, I thought that we're supposed to be looking at the nature of the allegations at the time of the notice of appeal.
We are at this point, yes.
And so if at the time of the notice of appeal, there hasn't been a transfer yet, and it was on a fast track in the district court, it comes up quickly and the person is still at least in the same facility, or at least there's no reason to think that he's not. Because I think a lot of these situations, there may be no particular reason that the court would know who's supposed to be doing this filtering at an outset. At that point, then there would be a nexus, hypothetically, and the allegations would go to imminent danger, and then IFP status would be granted, right?
I would need to see that in the full context, but in general, I think that is probably correct. And again, just IFP status could be revoked if it was determined that indeed the prisoner wasn't in imminent danger.
Okay. Make sure my colleagues don't have any different questions. Thank you, Mr. Dryer.
Thank you, Your Honor.
Ms. Gabba, we'll give you 2 minutes for rebuttal.
Thank you. Your Honors, I'd like to conclude with 3 short points. First, I think it's been mentioned, but the PLRA makes no distinction between a person, a plaintiff with 4 or 400 frivolous claims. Mr. Khan still has to pay the filing fee only in installments. So he has no interest in bringing an insufficient or conclusory claim here, only to be kicked out at the merit stage when he would still have to pay the filing fee. Second, this case is not conclusory. Mr. Khan's allegations are not conclusory. This court has an obligation to read to construe his allegations liberally, and even without that construction, I don't think that this court could come to any other determination on the assaults for the notice of appeal, the timing of the assaults for the notice of appeal. Mr. Khan alleges that he was assaulted on August 28th, 2 days before his notice of appeal, by Mr. Riggs, after he was placed in a cell with Mr. Riggs a second time after he had already been assaulted by Mr. Riggs previously. Third, the government has been discussing its affidavit. Even no matter what the government presents as rebuttal evidence, even if it was incontrovertible or appeared incontrovertible to this court, if he said that he wasn't even at USP Thompson, that would still be a factual dispute that this court would have to weigh the credibility of versus Mr. Khan's allegations. And that is a factual dispute that should be resolved, that this court is not equipped to resolve. It's not the proper forum to resolve. I see I'm almost out of time, and I would just conclude on the final point that nexus is not a problem here. Mr. Khan, under any articulation of the standard, satisfies nexus. He has his underlying legal claims are exactly the same as his imminent danger claims. There is a clearly traceable connection, and even under any other test that other circuits have adopted, he passes.
Thank you, Ms. Gabba. Thank you, Mr. Dryer.
Thank
Ms.
you.
Gabba, you and your team were appointed by the court to present arguments supporting appellant in this matter, and the court thanks you for your assistance. We'll take this case under submission.
Thursday at 9:30 a.m.